Welcome to Law Sessions. I am Jennifer Housen. In this law session, we are going to consider contents of a contract. Now, of course, in previous sessions, you've seen what offer is about, what acceptance is about, certainly what is consideration, and generally what goes together to form a contract. Now, though, what we will consider is what is included in a contract. This session will then cover the terms and types of clauses which are included in a contract. So over the next 4 segments, we will consider terms in a contract, including, of course, the contractual terms themselves or representations. We will also consider conditions, warranties, and innominate terms, as well as terms implied by the common law and some statutory implied terms as well. Now, the contents of a contract are known as terms or clauses. An agreement then will generally consist of various terms. Even the simplest form of contract will have terms. Even if it's an oral contract, it will have terms. Because the fact that I say to you, I will sell you my pen, and you say that you will pay £10 for it, well, these are the terms, these are the clauses. Now, on what terms am I going to sell it to you, for example? Am I going to give it to you immediately? Will I give it to you tomorrow? Do I have a week to give the pen to you? When do you have to pay for it? Do you have to pay for it immediately on receipt? Do you have to pay for it a week down the road? Well, even the simplest form of contract will have terms in them. Now, the main terms generally are, of course, the price paid, what the subject matter of the contract is. So, what is the goods, like my pen, or what are the services, if somebody is going to make something for you, for example. It is common, of course, for businesses to have standard form written terms, which can, of course, be extraordinarily lengthy, and precisely why it ends up being a matter generally for lawyers, because it will tend to be a situation where you are drafting terms in order to try and catch as many of the potential events that might occur. You know, what will happen, for example, where there is a hurricane? Do I have to perform my side of the agreement, and so on? So it tends to be where lawyers will, contracts can be drafted, certainly by lawyers, but by anybody else, be drafted where it has extraordinary terms. The employment contract, it has terms on, what is the salary, what are your working hours, and so on. So sometimes terms can be fairly lengthy. Now, it is not a requirement that terms are written in simple contracts, although, of course, writing is required in certain types of contracts. So contracts for the sale of land, for example, for you to be able to enforce it, it needs to be in writing. Mortgages and consumer credit agreements tend to be in writing as well. Now, contract terms may be express or they may be implied. Now, they may be classed as conditions. They may be classed as warranties. They may be classed as innominate terms. An odd word, but never mind, we will come back to it. Where a contract is formed orally, it may be difficult to establish which statements were made in the negotiation of the contract which amounted to terms and which statements were merely representations. Because as you will see shortly, it is important to distinguish between terms and representations. Now, statements made during the course of negotiations may either be terms or they may be representations. Now, if we look at terms, terms may be express terms. Express terms are those which are agreed between the parties themselves, for want of a better explanation, expressly. Or you may have terms which are implied. These are terms which are put into the contract either by the common law position as found in the courts or by statute. Now, statements, as I said, may of course be classified as a term, so normally of course being expressed, which if it is not fulfilled, the innocent party may bring an action for a breach of contract. So you may have a term which gives rise to liability, or it may be a representation, which if it is not fulfilled, the innocent party may bring an action for misrepresentation, but it depends, because it must meet a certain criteria in order to reach that height. And lastly, of course, you may have something which is what is considered a collateral contract. And that is where, in such circumstances, the innocent party may sue on the collateral contract, because a collateral contract is like a side contract. So you and I are agreeing, for example, that you remain in my house and I rent it to you. That may be the main contract. But there may be a side contract that you can farm the outside acre of land and then you sell whatever you farm there to me, but that is contingent on or based on you living in the house. That could very well end up being a side agreement. Now the main contract remains intact, and of course you can certainly have a collateral contract as well. Lastly, of course, you have a sales puff. And a sales puff, it is not a rude word. It is really a word that suggests that what you've said is not intended to be binding, and so it has no legal effect. So if you go back to a case we've looked at previously in the session relating to offer, we see that in the case of Carlyle, they were saying there that this whole issue about them and their smoke ball was really a mere puff. And they were saying, we were just saying, you know, this is so good. If you used it and you ended up getting the flu, that we would pay you £1,000 or whatever. The point about a puff, though, is, you know, think of I am the best show person in the world. You know, think of Red Bull gives you wings, for example. These are simply sales puff. So if we were to take the last two straight away and deal with those, so we've looked at, there are four things that you could generally look at when you're looking at terms. It could either be a term, it could be a representation, it could be a collateral contract, it could be a mere puff. Well, as I say with mere puff, it goes without saying that it doesn't bind. Now, when you're looking, for example, at a collateral contract, case, of course, that we can consider is Esso Petroleum and Modern. Mr. Modern had entered into a tenancy agreement with Esso Petroleum in respect of a new petrol station. Now, Esso's experts had estimated that the petrol station would sell 200,000 gallons of petrol. The estimate was based on figures which were prepared prior to them making the planning application for the petrol station. Now, the planning application permission changed the prominence of the petrol station, which would have an adverse effect on the sales rate. If memory serves me right, what had happened in the case was that it was supposed to have been on a main road, but the way that the planning ended up, the entrance would have been on a side road, and that of course is going to affect it, because it's easier for somebody going to a petrol station to pull off as opposed to have to turn off in order to get into it. Well, Esso made no amendments to the estimate, and the rent under the tenancy was also based on the erroneous estimate. Consequently, it became impossible for Mr. Modern to run the petrol station profitably. In fact, despite his best endeavors, the petrol station only sold 78,000 gallons in the first year and then made a loss, a quite huge loss actually, of £5,800. Now, the Court of Appeal said that there was no action for misrepresentation, as the statement was an estimate of future sales rather than a statement of fact. However, the claimant was entitled to damages based on either negligent misstatement at common law or breach of warranty of a collateral contract. So they didn't say that what Esso said was a mere puff. They said that when you look at it, you possibly could consider the whole thing in the context of a collateral contract, because arguably you were looking at the issue with the planning permission as something collateral to the main contract of the petrol station contract itself. Now, in turning to the two important ones in deciding whether statements amount to a term or representation, the courts look at four factors. Now, It looks at the parole evidence rule as one. It looks at the relative expertise of the parties, and then it looks at the importance of the statement, and it looks at the time that the statement was made. If we first consider the parole evidence rule, this is where the contract has been put into writing. What the law says is that only the terms included in the written document are terms that will be considered, and any verbal statement will merely be a representation. The second thing that is considered in the determination of whether you're looking at a term or representation is the expertise of the parties. Now, if the representor has greater knowledge, it is more likely to be a contractual term. For example, I'm going to buy a car and I go to the car dealer. He's the representor, and it is that knowledge in relation to the car he's selling me is, of course, within his own knowledge. Conversely, if the representee has the greater knowledge, it is more likely to be a representation. Now, two cases which show this, of course, are Oscar Chess and Williams and the Dick Bentley case. Now, if we look at Oscar Chess and Williams, Mrs. Williams purchased a second-hand Morris car on the basis that it was a 1948 model. The registration document stated it was first registered in 1948. The following year, her son used the car as a trade-in for a brand new car, which he was purchasing from Oscar Chess. The son stated that the car was a 1948 model, and it was on that basis that Oscar Chess offered £290 of the purchase price of the Hillman. Without this discount, Williams would not have been able to go through with the purchase of the new car. 8 months later, Oscar Chess found out that the car was in fact a 1939 model and was worth much less than they had thought. Now, they brought an action for the breach of contract, arguing that the date of the vehicle was a fundamental term of the contract and thus should give them grounds to repudiate the contract and claim for damages. The court said that the statement relating to the age of the car was not a term, it was a representation. They said that the representee, Oscar Chess Limited, as a car dealer, had the greater knowledge and would have been in a better position to know the age of the manufacturer than the defendant himself. Now, contrast that case with the Dick Bentley Productions and Harold Smith Motor Cars case in 1965. Dick Bentley knew the defendant, who was a car trader specializing in the prestige car market, and he had been doing this for some time. Now, it asked him to look out for a well-vetted Bentley car. So he wanted him to look out for a car that, as far as he was concerned, was a pretty good car. Now, the defendant obtained a Bentley and recommended it to the claimant. He told him that the car had been owned by a German baron and had been fitted with a replacement engine and a gearbox and had only done 20,000 miles since the replacement. Mr. Bentley, of course, purchased a car, but it developed some fault sometime later. The defendant had done some work under the warranty, but then more faults developed. It transpired that the car had done near 100,000 miles since the refit. The question for the court was whether the statement amounted to a term, in which case damages would be payable for the breach of contract, or whether it was a representation, in which case no damage would be payable because it would have been an innocently misrepresented situation. And the claimant had then also had lost his right to rescind because time had passed. And of course, we will look at misrep in another lecture, but for our purposes now, the court said that the statement was a term. Mr. Smith, as a car dealer, had greater expertise, and the claimant had relied upon the expertise. Now, when you consider the importance of this statement and the reliance, where the representee indicates to the representor that the importance of the statement is necessary, that it was important to him, then it is likely to be a term. And the case, of course, for that is Bannerman and White. In the case, the claimant agreed by contract to purchase some hops to be used for making beer. He asked the seller if the hops had been treated with sulfur and told him that if they had, he wouldn't buy them as he would not be able to use them for making beer if they had. The seller assured him that the hops had not been treated with sulfur, but in fact they had been. The court said that statement the hops had not been treated with sulfur was a term of the contract rather than a representation, as the claimant had communicated the importance of the term and relied on the statement. His action for breach of contract, therefore, was successful. Lastly, timing. The longer the time lapse between making the statement and entering the contract, then the more likely it will be a representation. And the case for that, of course, is Routledge and McKay. And in that case, the claimant acquired a motorcycle and sidecar by exchanging another motorcycle and paying £30. The registration document said it was a 1942 model, and this is what the defendant stated the year of the motorcycle to be when the claimant came to look at it. The motorcycle was in fact a 1936 model, but had been modified and re-registered by a previous owner. The purchaser went away to think about it and then returned a few days later. A written agreement was produced to the effect of the exchange, which ended with the words, "It is understood that when the £30 is paid over, that this transaction is closed." Now, the court said that the statement was a representation and not a contractual term. The registration document was not prima facie evidence of a contractual term. Neither party was an expert, and there was a lapse of time between the making of the statement and the entering into of the contract, giving the claimant the opportunity to check the statement. Furthermore, there was no mention of the date in the written agreement, and the words of the agreement stating the transaction is considered closed, excluded any possible collateral warranty. All right, we've considered the importance then of a representation and term. When we come back after this short break, we will look at conditions and warranties and also innominate terms.